Well, this is really very surprising. That
This will issue notice.
state.
How can it's more than a settled law right from Indra Swani that the executive has the power to do it.
Their own act which says, Virat, and the High Court earlier judgment says.
No, but the Supreme Court 9 judges bench says that the executive can do it even by an executive instruction. There is no legislation necessary for providing reservation.
No doubt about that. But they have made their own act in 2012 which says otherwise, that it will be done under, as per the procedure under the act. They are doing it under the 93 Act, Virat. And Virat, they are not filing counter. The High Court wanted to hear the matter.
Because I am really surprised what my learned friend is saying, Malats.
We'll stay this order.
Yes.
And if you want, we'll direct the High Court. One minute. We'll direct the High Court, we'll request the learned Chief Justice to direct the matter to be placed before some other judge.
I'm not,
it's surprising.
No, I'm not joining any issue on that. But what I'm respectfully saying is, Lordship may not stay today. There was one time.
40,000 teachers to be appointed, no promotions to be made, roster system cannot go on.
How can the executive just was the reasoning given by the High Court?
The reasoning is at page 11 and 12.
Come to para 16.
Yes, Vinod. But para 16, Vinod, may I place it, Vinod?
Yes.
Yes, please.
Directions contained in clauses 8.
No, para 16 of the impure order.
Yes, Vinod, I'm reading para 16.
The state ought to have placed.
Para 16.
There are two 16. The learned judges even forgot to correct the paragraphs.
Para 16.
Okay.
Para 16 is at page 11.
It is also at page. It is also at page 12.
My mistake.
Yes.
My mistake. I stand corrected. Your Lordship are putting the second para 16.
No, you want the first para, read the first para 16 also.
Not entirely. My Lord wanted you to read that. No,
you read your paragraph 16 first.
Lordship, please. Yes. The directions contained in clauses 8 to J in paragraph C61 need to be considered together and not in isolation. A particular line cannot be picked and highlighted. From the said directions, it is explicit that we have read down the expression Government of West Bengal and the government to mean the state of West Bengal in discharge of its legislative functions. We have also struck down section 16 of the Act since it empowered the state executive to amend the schedule and had consequently down 37 classes included in the exercise of section 16 of the state executive. We have also struck down section 5A of the 2012 Act which distributes the percentage of reservation in 10% and 7% to the sub-classified classes. However, prima facie...
Now in the teeth of the 7 judges bench that sub-classification is permissible. Now read it further, yes.
This is only about the judgment which matter SLP is pending before my Lord.
No, here you said that you want, I think that SLP is not pressed.
No, Your Lordship, what happened?
It's very much pressed.
No, they were pressed.
They were pressed. They have only said that we are...
Allow...
Let us complete the reading of this paragraph.
Yes, Lord. However, prima facie it appears that respondents are proceeding in hot haste and are attempting to bring in the self-same classes and to reintroduce the percentage of reservation which have been struck down by this court by executive orders and not in exercise of state legislative functions, and that too before we can scrutinize the steps taken by the Commission in terms of our earlier order dated 6th May. Well, my friend Milord had said on the last date of hearing in May that we are doing a resurvey now and we are going to have after fresh survey we will come out with the list and inform, so Your Lordship put it in July. That's the last order, I can trace that immediately. But that my friend did not say at that time that he is not pressing his SLP. The SLPs are very much pressed, my Lord, but Your Lordship declined to grant any stay there. Now, my Lord, the next, second para 16. The state ought to have placed the reports and the bills before the legislature for amendment and introduction of classes in the schedule of the 2012 Act. The executive notifications are in direct conflict with the judgment and the same had not been issued under the 2012 Act. I'll show the notification just now. This court had categorically observed in the said judgment that it had not interfered with the executive orders classifying the 66 classes prior to 2010. The said judgment had not been interfered with by the Honorable Supreme Court, and that as such there can be no hindrance in conducting the recruitment process as well as the admission process, taking into consideration the 66 classes of OBC as existing prior to 2010. So those people who are prior to 2010, they can be recruited. There is no problem at all. Now, my lord, for the reason, therefore, the stay. Now, my lord, may I just show one notification, my lord? If your lordship will kindly have with me, my lord, volume 3. My lord, volume 4, my lord. I'm so sorry. My lord, there is a volume 4 that they have annexed, my lord.
Sure.
Your lordship may see this at page 1267.
What's wrong with it? It's fine.
It is from pages 1118. You will see in the top, pages 1118 onwards.
Triple 18.
No, but it starts from 1118. I am at 1267. But I'm sorry, Lord. I was just watching to the court to help the court master.
This notification.
That is the volume, Lord, which starts with, because the volume number is mentioned right in the foot of the page. In the index. May I place this, Lord? 1267.
Yes.
This is the gazette dated 10th June. Now, my lord, below that, your lordship see so and so number dated 27th May. Whereas the backward classes have been defined in clause A of section 2 of the West Bengal Commission of Backward Classes Act, there so and so, to mean such backward classes of citizens other than the scheduled caste and scheduled tribe as may specified. Whereas lists have been defined in clause C of section 2 of the said act to mean lists prepared by the government of West Bengal from time to time for the purposes of making provision for the reservation of appointment of posts in favor of backward classes of citizens, which in the opinion of that government are not adequately represented in the services under the government of West Bengal and any local or statutory.
This has been stayed, Malad. I don't know why my learned friend is reading it.
Therefore, my lord,
All have been stayed.
with all due respect, my lord, your lordships are saying to stay this order, the order of the High Court. Therefore, my lord, I am trying to show why it was stayed.
What?
My friend, my lord, observed, my lord, that we will stay this order of the High Court. Therefore, my lord, I am placing it. I can, lordships can keep it next Monday.
For what?
File a short affidavit.
Have it next Monday.
And lordships are issuing
In the meantime, there's a stay, Malad. There are contempt proceedings. Contempt proceedings are pending. 9 lakh seats have to be filled.
Provides that the reservations cannot be provided by executive instruction.
No, the
No,
statute
no, no,
sets out the, can I, my lords? The statute sets out the procedure. This issue was raised in round 1, my lords. They said, where is the question of insisting that only a law can be made? We argued, therefore, pointing out to the court that there is no impediment under 16 to make to provide for reservation without a law. But if a law is made, then, my lord, the state is bound to follow the rigors. My lord's judgment in Ram Singh squarely covers it. In fact, the Union of India, my lords, in Ram Singh's case, raised precisely this argument, saying that why should I consult the Backward Classes Commission? Why should I ever go through any procedures? 16 is an independent right. They relied on Indira Sani. Indira Sani was referred to. My lord still said in Ram Singh, yes, you can make reservation independently under 16. But the moment you make a law, then you have to follow the rigors of the law. That's point 1, my lords. And this is
Again, they are not telling the
no, my
fact.
friend would bear me out.
Section
my lord.
16 is struck
No, my
down.
lords, I'm sorry, my lords. He should not interrupt, my lords. With great respect.
Struck down earlier, Malad is reading
My friend
section
would
16.
bear me out, my lords. This is a very crucial point. This is a red herring they are raising. This is clearly a red herring, my lords.
Section 16 struck down, 340.
And one more thing, my lords.
342A, Malad 3 gives you the power, gives the power to the state government, Malad.
Ah,
Yes, sir.
16.
If
Give me the
if
new
your
act.
lordship kindly have
New act. Give me the new act.
act, my lord, at page number.
We'll show, there's one more thing I wanted to say, my lords. We'll show 16 also. One other thing. So based on Ram Singh, there is a full discussion in the earlier judgment saying that now that you have made a law, you follow the procedures. My lord will also recall number of states have made laws.
Page-
Tamil Nadu, Maharashtra,
second.
UP, various other states. In fact, Tamil Nadu, my lords, went to the extent of wanting to place it in the 9th schedule itself. So once a legislative rigor is brought in by the state itself, then it can't sidestep, my lords, and say, I have power under 16. And this precise, and they passed the law in 2012. They tried to provide for reservation under the 2012 Act. without consulting the West Bengal Backward Classes Commission. Therefore, it was struck down. They came before my lords. My lords heard the matter and did not give them a stay. At that stage, they come to my lords and say, no, I will make a fresh survey of all the classes. What we do at that stage is take out, my lords, only that 112 or 113 which has been set aside in round one. Same thing, my lords, they reintroduce in 1.5 months' time. Now have a look at 16, my lords, 16 of that act. Just see that, my lords. Yeah, that's correct. This.
Based on interim reports of the commission just now. There is no final report of the commission.
So, no, but it may add.
16, my lords.
Survey is continuing.
The state government, may I read that?
I know.
The
but-
state government may, by order published in the official gazette, add to, amend or alter any schedule. So,
So it gives a power to the state government.
this was struck down. What, can you just?
On what ground this has been struck down?
No, please come to 2H, my lords. Please come to.
Last time also your lordship asked the same question when the matter came up.
Please come to this, my lords. At page.
What is the procedure prescribed in this enactment?
Now, please come to that, my lords. Please come to 2H.
2H.
Yeah, 2H, my lords. First, the definitions, then I'll show the other provisions.
Yes, sir, it's specified in this thing. By notification related.
Other backward classes, my lords, got that? May I read that, my lords?
Yes.
Other backward classes shall mean such classes of citizens as specified in Schedule 1, other than scheduled castes and scheduled tribes, and include such classes as the state government may by notification.
So again, the power is given to the state government.
No, there, my lords, there, here the latter part was struck down by the High Court, saying that it does not provide for consultation with the Backward Classes Commission. And that order has not been stayed by my lords. That's part one, my lords. Part Indra Sani, my lords will recall, specifically requires that Backward Classes Commission must be consulted. The entirety of the exercise.
So it also requires that a data has to be collected.
Exactly, my lords.
So whether the data has been collected by the.
No, my lords, I'll show their counter now. Now, please see their counter.
Data has not been collected, Lord. It's only an interim report given. They are saying themselves in the notification that while this is continuing.
Well, as I am
Just have a
surprised.
look at 597, my lords, the
have a
counter
word.
of the Backward Classes Commission.
That is why I'm requesting.
Just have a look at, my lords.
May I have a word?
Just see, my lords. Please see page 500.
597.
Please see, my lords, page 597.
Volume
Volume 2, my lords.
2.
Please see, actually, my lords, the document would itself start at, my lords, in 596. This is the Backward Classes Commission's document. Now, please see what they say. They are saying that they will do a sampling exercise. That starts at the top of 597.
Challenge.
Propose sampling methodologies for selection of households for benchmark sample survey on backward classes in West Bengal. My lords got that? Then, my lords, the methodology is given. I will not trouble my lords with the methodology. But what is important is after...
Identification of backward class population.
No, please see. Now, please see the third para there. As the data, my lords, get that para? As the 597.
Yes.
As the data on the population and estimated population of each class in the state could not be made available by the Backward Classes Welfare Department and could not either be obtained from any other source, P here may be considered as 50%, that is 0.5. They don't have data. They simply take a sampling method and say, I will use a formula and decide whether a class is backward or not.
This is done by the commission.
This is done by the commission. Today, that is that report which they want to sustain.
But this is the previous.
What they are trying to say is this, my lords, the commission has given me a recommendation.
This is, he's
Then-
reading the previous order where I told your lordships, we'll go back to the commission. Commission has done that exercise. That is here. He's not even referring
No,
to
I
the right.
want more.
judgment.
What-
Wait a second.
That is at page number?
Page 791, not challenged in the High Court.
I'm.
Not
benchmark
challenged.
survey itself has
That's
been
not the
challenged.
High Court finding, my lord. Now let me say what you're just completely, with the greatest respect, not telling the facts to the court.
Affidavit filed in the
One
High-
second,
One
just hold
second.
on.
I'll show the affidavit filed in the
Hold
High Court.
on, hold on. The High Court judgment doesn't proceed on the basis that the Commission has not done that exercise.
Of course, yes, the High Court says.
Where is
it's done
that
in
order?
post-haste.
Where is that finding?
The whole thing has been done in post-haste, it's the specific finding.
No,
See, Malas, 791. The whole exercise has been done. It's all done. 76 have been added. 66 should. All that done, not challenged. That's not the finding of the High Court. When staying this matter. And this is just one community. There are many like this.
So one more thing.
For 1 week. In the meantime,
No,
they
sir.
should be stayed with the impugn order.
Look, just one more thing I wanted
We'll
to.
hear in the next.
No, I understand, but just one more thing on the
I was
state.
not-
On this, on the
If
state.
you are willing, we will direct the High Court decide the matter within a stipulated period. Till then, the status quo shall be maintained and the matter will be heard by the bench, not consisting of the learned judges.
Your Lordship may, if your Lordships are giving a status quo, we have no problem, my lord.
No, what?
The proceedings would proceed.
No, status.
No,
quo-
we have not, there's no contempt which has been pressed, my lord. In fact, it's been adjourned. There's just one other thing I wanted to show, my lord. Just before, on
They
this.
are against us now. There's a contempt matter pending.
One minute.
Within 7 days of
The counter of the commission, the counter of the commission in this very proceeding, the present proceeding, 1341 it starts. At 1346, my lord, just volume 4, my lord, just have a look. My lord.
Volume 4, yes, volume 4
Volume
is.
4. 1341.
proceeding, commission has not filed any affidavit.
They have,
They have filed, my lord, 1341. There's a reply afterward filed by them. 1341 at 1346, my lord.
Saying what?
My lord, have that para G. Subsequent to the filing of the said SLP in or about October, November 20.
Para.
Para G, my lord.
Para G at 1346.
346.
Yes.
Now, subsequent to the filing of the said SLP and in or about October, November 24, the Commission received a series of fresh representations and applications from various communities and groups, including 113 classes, addition of which were set aside by the judgment dated so and so for the reasons contained therein, and 4 new communities. Through the sets fresh applications, concerned classes sought inclusion in the state list of backward classes, primarily on the grounds of socio-economic practices, etc., etc. Then, please come straight away to 1354.
1354, my lord, para R.
Para R.
Previous or?
Thereafter, the 461st meeting of the commission
Present one.
held on such and such a day,
Para.
are, my lords, at 1354.
1354.
Yes.
Now, the members, methodology of survey, my lords, are there.
Yes.
The members of the commission deliberated upon the methodology of the survey proposed by so and so and so and so. It was discussed and agreed that survey is opposed to a census and the two cannot be mixed up. A survey on its own means general consideration of something, appraisal. This can be done by competent statisticians or agencies opposed to a census, which is only done by the Registrar General. 93 Act also does not envisage a census or survey of the whole population for the inclusion of classes in the state list of OBCs. There will also be an absurd and unworkable proposition that every time the commission is considering inclusion or over-inclusion, exclusion of one or multiple classes, it has to embark on a survey of the whole population of the entire state. An exercise as so large as a scale could only be done logistically in a census by the central government. In fact, conducting a full-scale census would not only involve exorbitant financial costs, but may also delay timely policy intervention. On the contrary, a survey allows focused data collection and is administratively feasible and also economically prudent. Having regard to this, the commission resolved to conduct the survey using the Cochrane's method for sample size determination of the whole population, which is a universally accepted statistical method. Please read this with 597, which I read out, my lords. They don't do a survey at all. They give, my
We
lords.
do the survey, that's what they say. They are given the methodology.
They have not, my lords. They have just, my lords, simply taken.
Issue notice. In the meantime, there shall be stay to the impugn order.
Well, then we can continue with our promotions and
We
everything.
cannot say, we are saying that there shall be stay to the impugn order.
Well, let it be heard by Malat, I would suggest.
We don't know, otherwise I will have to assign it to some other bench.
Because,
Yes,
yeah,
Once we start with the reference.
well, what happens is, Malat, they're moving in contempt now, Malat, that's.
Where is the contempt? We have state that order, no? We have state the order.
No.
If you are willing, come with the proposition, we'll,
If your lordships are asking the Honorable High Court, requesting the High Court to not consider the matter and decide within a certain time.
Yes.
And in the meantime, status quo be
No.
maintained.
no,
We have no problem.
in the meantime, we don't want, whatever is there, if the commission has followed some methodology, which may be correct or not correct, that will be decided by the High Court finally.
But Milord, if your Lordship stay the order and Milord, then they will just make all.
Yes, will stay the orders. Prima facie, the order is totally, patently erroneous. Thank you. Next matter.
Deeply observed.